आपण अगदी थोडक्यात पण महत्त्वाच्या विषयाबद्दल सांगितलं. यानंतर आपण सगळे ज्यांना ऐकण्यासाठी इथे जमलेला आहात, सकाळपासून आतुर आहात, ते आपले पुढचे वक्ते आहेत, ज्यांचा जन्म 1969 साली मुंबई येथे झाला. ही स्टडीड ॲट सेंट Teresa High School, Cherney Road, Mumbai, and graduated in Life Science and Biochemistry from St. Xavier's College, Mumbai in 1990. He completed his advanced diploma in Computer Software Systems, Analysis and Applications from Apple Industries Limited in 1991. He completed his postgraduate diploma in Personal Management and Industrial Relations from Rajendra Prasad Institute of Communication and Management, Bharatiya Vidya Bhavan, Mumbai in 1992-93. He completed his LLB from Government Law College, Mumbai in 1995-96 and LLM from Mumbai University in 1997 and 98. He worked as a senior clerk in Western Railway, Central Service from 22/2/1990 to 13/1/1997 in the Establishment Administration Department. सकाळच्या सत्रामधला प्रश्न, नोकरी करून जज होता येईल का? यू विल गेट द आन्सर्स. तुमच्या सगळ्या प्रश्नांची उत्तरं बहुतेक या माहितीमध्ये मिळतील, ऐकलं व्यवस्थित आपण तर. ही कम्प्लिटेड हिज इंटर्नशिप ॲज ॲडव्होकेट फ्रॉम 14/1/1997 to 13/1/1998 अंडर मिस्टर PY कुलकर्णी, ॲडव्होकेट इन द स्मॉल कॉज कोर्ट. 1997ला इंटर्नशिप 1 वर्षाची कंपल्सरी होती, त्याच्याशिवाय सनद मिळत नव्हती. इन जुलै 1998 ही जॉईन द चेंबर्स ऑफ मिस्टर अतुल मोतीलाल सेटलवाड, senior advocate as junior counsel, and was attached to Mr. Chandrasekhar Manohar Korde, senior advocate, as his junior at Mumbai. In 1998, he was confirmed the Firdos H.J. Taler Khan Memorial Gold Medal, the late Dr. T.K. Tope Prize, and Shri G.N. Joshi Prize by Mumbai University for securing the highest marks in Group 5 Constitutional and Administrative Law at the LLM examination. He started his practice as junior counsel on the original side of the Bombay High Court in the year 1998. He practiced on the original side as well as the appellate side of the Bombay High Court, mostly in matters relating to constitutional law, land acquisition, references proceedings, cases under Maharashtra Regional and Town Planning Act 1966 and Maharashtra Land Revenue Code 1966 and commercial laws. He also appeared regularly in the Maharashtra Land Revenue Tribunal, Mumbai City Civil and Session Court, Mumbai, the Special Court at Mumbai, and in quasi-judicial proceeding before revenue authorities. From 1998 to 2000, he was a part-time lecturer in land laws, environmental laws, and civil procedure code in Siddhartha Law College at Mumbai. He was standing counsel for the custodian in the Special Court, trial of offences relating to Transactions in Securities Act 1992 at Mumbai from year 2000 onwards. Elevated as an additional judge of the Bombay High Court on 23/8/2019 and confirmed as a judge of the Bombay High Court on 1/7/2021. I kindly request Honorable Justice Shri Milind Jadhav Sahib, the Chief Speaker and Chief Guest of today's program, to enlighten us on the topic Laws on Matrimonial, Evolving Perspectives and Practices.
Please have your seat, all of you all. A very warm morning to all of you all, especially on a Sunday morning. Since I see a lot of students, let me first draw the students into the whole session today. And I'll be speaking on evolving perspectives and practices in matrimonial laws, which is the theme of the calendar for 2025 of Vidhi Foundation. To begin with, I requested Mr. Shaligram, who wanted to leave, to just wait for 2 minutes, because I want all of you all to know that I had the privilege of working with Mr. Shaligram 15 years back for quite a considerable length of time on a trial matter. A suit which was filed with respect to salt pan lands, in the Thane district court. In the course of my working, I ended up having several conferences with Mr. Shaligram in his office. Sometimes he used to come to our office in Mumbai. And whatever was spoken about him is indeed true. Let me tell you that. He's a living inspiration, a person who has helped everybody. And none other than me can vouch for it because of my personal experience of working with him. So on this momentous and milestone occasion of he being felicitated, who other than I could be proud of that? I am really thankful to Vidhi Foundation for taking this step and felicitating and honoring and acknowledging the life of those who have made a difference to the legal fraternity. Thank you, Mr. Shaligram, for all your wonderful company that we used to have, we used to discuss. And I remember distinctly one particular meeting in his office. It was fixed only for determining the marking of exhibits in a suit, in a trial. And we had a very, very lengthy meeting, I must tell you that. On every exhibit, whatever he said were pearls of wisdom, at least for me, because I was barely about 10, 15 years old, in practice at that time. But I really benefited from him. Mr. Shaligram and Mr. Chaudhari, both of y'all, thank you very much. This is the second instance, I had gone to Kolhapur for giving a lecture under the CLEP program, the Continuous Law Education Program. And that is the place where for the first time they felicitated and honored about 10 similar people, who had, spent their life helping the legal fraternity. And this is a very nice thing, a very thoughtful concept. Because ultimately, in the sunset of our life, if somebody acknowledges, it's a very wonderful feeling. Thank you for making a difference to the life of the legal fraternity, Mr. Shaligram and Mr. Chaudhari. I see an eclectic mix of students and probably those who must be practicing law at the bar. Some of them are from the teaching faculty also, I am told. A couple of known faces, Mr. Deshmukh was sitting there, I think he left. And that gentleman over there next to Mr. Shaligram, they all appear before me, who are in the first line, some of them. And my friend Mr. Sandesh Patil. In fact, Sandesh Patil is the only face I knew who came to meet me day before yesterday. And I told him, yes, I will be there. And when the gentleman, the president had come, I said, sir, I don't know any one of y'all. I'll tell you why, because, with our little experience, we have learned a lot of things. So one of my experience which will make you laugh is I went for a function, I delivered a lecture, I felicitated a few students. And the next day the photograph was flashed in the newspaper next to the president of the institute, saying so many things about the antecedents. So many a times, we don't realize where we go, But sometimes there is an inner gut feeling, So the gentleman president had come to my chambers 2-3 weeks ago or 4 weeks ago to invite me. And since my dates were free on the calendar, so I said, very well, I'll come. And then he asked me, sir, we are thankful to you. I said, you need not be thankful. Since I don't know any one of you, I am happy to come. But I did not know, that this is going to be such a lovely diaspora of gathering of students, an eclectic mix of all people from all walks of life. I am grateful to the introduction given, The gentleman spoke in chaste Marathi initially, and I thank him for that. मी सुद्धा मराठा आहे आणि I encourage Marathi in my courts also. But one of the reasons why I speak in English is only in order to impact the concept that yes, English is the language of the court, and it is going to help all of us in trying to achieve our objectives as soon as possible. Primarily because we all have only one life, remember that. It has to be lived in 3 or 4 phases with lots of priorities, several priorities. And therefore, we don't live for 300 and 400 years. So whatever little life we live, we need to achieve as much as possible. So for the students, to begin with, before I jump to the main topic, three things are necessary. I just came 10 minutes before time, and I was sitting in the antechamber there. And I overheard some of the earlier speakers tell you all about Marathi language. They tried to encourage you all, about Marathi. And they said, don't worry, you need to, English is also the language, but Marathi is also encouraged. Well, that was really heartening. But remember one thing. English, because it is the language of the court, we have embraced that language. And I'm proud to be an Indian because our Indian diaspora has embraced English much faster, much better. And I'll tell you all how it has been translated into the laws also, which have evolved. And more specific on matrimonial laws. For the students, 2 specific things are required when they are studying law or when they are having a dream of getting into the legal profession. One is undoubtedly industry. That is hard work. We all are adept to the saying, no substitute other than hard work, So industry is something which is required. Apart from industry, there is intellect. Intellect means you will have to now grow your mind to understand. The principal judge of the family court told you maturity is required. Sometimes you don't understand at the initial stages. But this is an evolving world. We all learn every day. I learn every day in my court. So industry and intellect is something which all of y'all at all stages of your life, and more particularly when y'all are students, which y'all will have to imbibe. It may come to you in different forms. Someone of the speakers said that you'll have to read, you'll have to understand the ambiguity, interpretation of statutes. But these are the 2 fundamental things which can be acquired by y'all over a period of time. Nobody is born with all these things, remember. If you have chosen the legal field, y'all can acquire industry and intellect. For which the students will have to develop some of their backward integration forces. Y'all will have to now start cultivating having friends with common interest. If you have to achieve your objectives of becoming a lawyer or getting into the social field as early as possible. Acquisition of knowledge is important. You all may do further studies, higher studies. Avenues are open. That apart, healthy mind, healthy body will have to be started practicing at this stage onwards. Now, once you have industry and intellect, the only other thing that is required for the legal profession is nothing but integrity. What is integrity? The most fundamental word which we all know is honesty. But let me tell you, we used to laugh during our practice days when we used to share a joke with each other. We used to say there is no honest lawyer. So I used to sometimes feel, I used to ask my senior, sir, why is that? Why do you say? He said, no, there is no honest lawyer, because if we get a chance, we slip. Don't we? Yes. But what we need to know is not to transgress limitations. Okay? Honesty and integrity will have to be at the core of our work. If these three issues are practiced, I can assure you, we all can be like Mr. Shaligram or Mr. Chaudhari, who are here today. They form the spine, the fulcrum of the legal practice, which all students will have to imbibe. Now, coming to the topic which was given today, it is evolving perspectives and practices of matrimonial laws. Now, this is a topic which I'll be speaking to you all in 4 different segments. So the first segment will be the segment relating to the evolution of the English language. I have circulated a paper to all of you all, which I normally do whenever I go and deliver a lecture. It just gives a brief idea of what I'll be speaking. The idea is that for you all to ruminate on what is stated there. And believe me, all this is bound to help you all. So the first segment relates to the evolution and acceptance of the English language. The second segment relates to the British jurisprudence of matrimonial laws in our country. The third segment is the Indian jurisprudence. And the fourth will be trivia. So, to begin with, as students of law, I will request you all to start imbibing the habit of becoming a good reader. Read, become a student of history. The idea is to draw you into the legal profession. If you are a good student of history, I can assure you that law will be multifaceted and interesting for all of you all. So when we look into the history, do you all know that English was never the language in our country barely 3 centuries ago? Barely 3 centuries ago. And therefore, when the East India Company came to India as a group of traders, and if you look into the history of the East India Company, it was a conglomeration of 23 enterprising traders formed in England. And what did they do? They said, let's go and conquer the world by our trade. So when they set foot in 1608 and they spread their tentacles all throughout India through their trading of spices, they took almost 100 years or maybe 125 years thereafter. 125 years for the British Crown to take cognizance of the fact that yes, our trading community has set foot in India. Now we can go to India and attempt to do something more. But believe me, that do something more was nothing but to also educate us. And therefore, we need to be slightly thankful to the British Crown for that. The dominant legal system prevalent for matrimonial laws in those times were the Mughal courts. We had the British India. What was this British India? It was mainly concentrated in 3 places. We all know, we've heard about Fort William. What is Fort William? The old Calcutta. Fort George, Madras. And then we have Bombay. So this was British India. A large part of India was ruled by a lot of princely states. They had their own courts, they had their own systems in place. We are all aware about the systems which Chhatrapati Shivaji Maharaj also followed in his courts. The Mughals mainly were predominant because of the Muslim law customs and practices. Most of the princely states embraced the concepts of Hinduism, Hindu law from the Puranas, Vedas, Upanishads, and the customary practices that were followed. What the Britishers found was that if we have to make a difference in this country, we need to do something. There is something out of place. And I've used the word anachronistic in my lecture, in my write-up. The reason for using that word is because they found that certain practices needed to be intervened. But it was not easy because we were one of the most diversified lot, the Indian diaspora. So how do they began with? So they began with by giving the charter and establishing those munsif courts in Fort William, Fort George and the state of Bombay. What are munsif courts? Because they were traders. Whenever there was a dispute between the traders and the locals, they had to be tried. So therefore they started by beginning and evolving with munsif courts. After the munsif courts, they had the Regulating Act of 1773 and India Act of 1774. These two acts gave the British Crown military, financial and political control over British India. The Act of Settlement 1781 was something which gave power and jurisdiction to the Supreme Court of Calcutta, gave recognitions to the laws for the usages of the customs of Hindus and Muslims which were predominant in our country. We have still not entered the era of the statutes. The Charter Act of 1833, enacted by the British Parliament for the first time, 1833, and that is where, the statutory provisions started. That gave power to the Governor General and Council to decide, enact, and start enacting the laws, the statutory laws. But these laws had to be adapted to the Indian conditions. So in order to make them adaptable to Indian conditions, the Governing Council was given a diktat that yes, you can use the English laws which were prevalent for more than 400 years, but they will have to be adapted to the Indian conditions. So three persons made a big difference. And during our school days, we may have heard their names in the history subject. One was Sir Warren Hastings. You all may have heard about him. One was Lord William Bentinck. And the third, obviously, which most of the lawyers, almost all lawyers know, is Lord Macaulay, Thomas Babington Macaulay. So these three gentlemen made a difference. Academically, they were proven. So when they were appointed as the chief of the Governing Council in India by the British Crown, and when they set sail, came to India, what they found was that there was something missing. They thought to themselves that if we have to make a difference, it will be very difficult for us to break the existing system of gurukuls and pathshalas. And that was something where they felt that something had to be done. You know how they began with? They began with a study. A lot of Scottish missionaries set sail in a ship from England. They came and landed in India. And they had only one diktat from the British Crown. It was to undertake a study. And I'm talking about the early 19th century, between 1800 and 1825 or 24. What they did was they went all around British India. At some places in the princely states, they were not allowed. They went around. There was a Scottish missionary called William Arlam, whose name is there in the write-up. He went around and he prepared a paper That paper was given to the governing council. On the basis of that paper, Lord Macaulay prepared a paper called Minutes on Indian Education. And he felt that if we have to make a difference to this place, the first and foremost thing which we may have to intervene and change is language. I am no proponent of English language, let me tell you that. It's only because of my educational background that I speak in English. But what I want to tell you all is why English has been embraced by us. Just see, within a span of 2.5 centuries, only because of the English language, we have come this far. And therefore, it is a powerful tool of communication. Believe me, I mean no indifference to somebody who speaks in Marathi or is educated in Marathi. Absolutely no issues. I had Marathi in school right up to college. I studied Hindi. But you need to embrace English because professionalism calls, and that is the degree of acceptability that you may have. I don't want any one of you all to be belittled. Let me tell you that. And that's the reason why I say yes. Just see the history of our own country in the past 2.5 centuries, and you yourself will be, you'll aspire yourself to be something like that. English language played a major difference in the British jurisprudence. High courts were established, as you all know, in the by the High Courts Act of 1861. You all will be surprised to know that the British Crown established 4 law commissions between 1837 and 1879. And it is nothing but as a result of these 4 law commissions that we have a plethora of statutes which were enacted. The law commissions were established in 1837, 1853, 1861, 1879. Before I go into the statutes, we all know how the Indian Penal Code was drafted. The Navtej Singh Johar case, the second judgment written by Justice Nariman, gives a little bit of history about that. It gives the exact date when the draft was prepared by Lord Macaulay. And we all need to be thankful. That particular year, in 1835, Lord Macaulay decided, because he was a bachelor, not to go back to England. Because the practice in those days was, in the summer holidays, they have to set sail to England. The heat would be unbearable in India. So Lord Macaulay, we have to be thankful that he was a bachelor, because we all benefited. He stayed back in India. He retired to a bungalow in Ooty, which is even in existence today, Lord Macaulay's house, next to the Ooty Club. He ensconced himself over there for 3.5 months and prepared the draft of the Indian Penal Code. Now please see, the draft was written in 1835. Indian Penal Code was ultimately accepted and enacted when? In 1861. The journey between 1835 and 1861 is beautifully explained by Justice Nariman in this Navtej Singh Johar judgment in paragraph number 272 onwards. If you get time, just read that. It had to undergo several adaptations and changes. You know why? Because it had to adapt to the Indian standards, Indian conditions. So someone who took trouble for us, we need to be thankful to them. The early courts, when we talk about evolution, in the early courts which were established, you all will be surprised to know that we had English judges presiding in those courts. You know who were their advisors? The jury. they were Pandits and Maulvis. They used to consult Pandits and Maulvis who used to sit with them in the courts on the issues which were deliberated in the courts. Now, this is the evolution of the matrimonial laws because of customary Hindu practices. So one of the judgments, the landmark case which I have written over here is of 1786. It is the Do Den Munnulal versus Gopi Dutt case. I have got it with me incidentally. The language in 1786, which I will call, was English language, but with a difference. Pandits were consulted, Pandits. In fact, the next judgment which is there in the landmark case, a particular judge, Justice Stones, he consulted more than 51 Pandits. I've got that judgment also. Very interesting, you know. So this is how the beginning happened. Just compare and imagine that beginning with what we have achieved today and what we are doing in today's times. That answers the theme, the question which has been chosen by the Vidhi Foundation for this year, the evolution. So the first ever statutory provision was the Bengal Sati Regulation Act. You know, 4 or 5 customs were prevalent in those times. Sati. Sati, we all know, was embracing the fire funeral, by the wife. But actually, if you look at the history, Sati was nothing but it was a marriage form performed by the wife by setting herself on fire on the funeral pyre. It was a form of marriage. That is how the history is. Because marriage was so sacred and sacrosanct in those days, this sati practice was prevailing. And there the Britishers felt that something anachronistic was happening here and it required a change. So, first ever legislation was Bengal Sati Regulation 1829. Don't get carried away with the word Bengal, because Bengal was Fort William. The large part of Bengal and Bihar was initially known as British India. It spread its tentacles then to Fort George in Madras, then to Bombay and many other places. After that, the other prevalent practice in those days was widows' remarriage. It was considered to be a taboo. So, the Hindu Widows Remarriage Act 1856 was enacted, which legalized widows' remarriages in all jurisdictions under British India. That is, all jurisdictions under the East India Company. Now, please remember this year, 1856. This was the time where the British Crown had not taken cognizance. It did not try to set foot in India. It was much later after that. Though the India Act, the Regulating Act were passed, but the British Crown itself took more than 2 centuries in order to do the spade work. And, we all are the beneficiaries today of the spade work done. The Indian Divorce Act was the next act, which was enacted in 1869. The Parsi Marriage and Divorce Act 1865. And these acts governed the relationships between spouses. So these are the initial matrimonial laws which were enacted, tried. Of course, the Indian Divorce Act, Amendment Act 2001 has substantially changed the original act. Now there are 2 acts. One of the acts, the Hindu Marriage Act, was spoken by the learned family judge today. The Special Marriage Act, 1872, was one of the first precursor act. We do a lot of matters, if you are practicing matrimonial cases, you do a lot of matters under the Special Marriages Act. And just to evince your interest a little bit, a question was posed by the learned family judge. If you are married under the Hindu law and then you get married under the Special Marriage Act, what will prevail, what will not prevail? To answer that question, Mr. Judge, all that I will say, what prevails is nothing but your status and power and money in the society. Believe me, if you have status, power and money, you can get married under different laws. To give you an example, should I give the example or no? So we had, I won't take their names, but we had the yesteryear superstars actor, who was well married with two children, and then he decided to marry a co-heroine with him. But then, she was also married, and no, she was not married. But then the problem was the law. So he took recourse to this. Come on, let's go and change your name in the government gazette and then use the law, the Special Marriage Act. It is only someone like you who suggested that to him. And he is living happily ever after. So, these are the loopholes which lawyers will have to now look at. The learned family just talked about interpretation of statutes and the ambiguity in certain things, which generally students find it difficult to address. But then these are the things which you all will come across. Now, the Special Marriage Act, 1872, was the precursor of the Special Marriage Act post-independence in the Indian jurisprudence, that is 1954. Very early, we had the Guardianship and Wards Act of 1890, which was enacted, where a lot of problems, and see, the matrimonial laws are now not, relegated only to the spouses. It also percolates down to the children nowadays. And I'll be introducing a couple of cases, very interesting cases, because the Indian jurisprudence has been developed until September 2023 last year by the Supreme Court. So there is one entry in the write-up which is very interesting, and all of you all will be very proud. Chhatrapati Shahu Maharaj introduced 3 legislations in the early 20th century. 1919 was that year. Just see what kind of progressive thinking Chhatrapati Shahu Maharaj had. The Marriage Registration Act, 1919. The Prevention of Cruelty to Women Act, 1919. For the first time, it defined physical cruelty and mental cruelty to women in 1919. And this was the kind of progressive thinking about the person who was the precursor, Chhatrapati Shahu Maharaj, in Kolhapur. And there was also the Kolhapur Divorce Act, or the Kolhapur Divorce Act, 1919. Immediately thereafter, we had succession issues. So Indian Succession Act 1925, which is the precursor and which is followed even today, came to be enacted. During British jurisprudence, just see the evolution now. 1773 Charter Act, 4 law commissions. The law commissions enacted civil laws, criminal laws, and these matrimonial laws. And over a period of time, how these matrimonial laws started evolving themselves. The Child Marriage Restraint Act, 1929. Why was it enacted? Because of the child marriages prevalent in those times. Unfortunately, we are just 100 years after that, enactment. Not even 100 years, I can say. But today's statistics are that at least in 5 to 7 states in India, 5 to 7 states, I must say, child marriages are still prevalent. And see, we are a conglomeration of 26 states. We need not be pessimistic, because ultimately tomorrow, all the students who are sitting over there are going to be the future of our country. And it is going to be in your hands to ensure that this statistics comes down, and we have a state where it is no longer prevalent. No longer prevalent. That's primarily because of the habits and the customs that we have been growing up with. An interesting act in 1936 was passed. This was the Bangalore Marriages Validating Act. It is no longer prevalent. You know why it was passed? Because the priest in Bangalore ended up marrying a lot of couples, a lot of people. The problem was their personal rights and proprietary rights were not recognized. The British government had to actually enact a statute for that. That all those who were married by this particular priest, whose name was Sir Walter James MacDonald Redwood, all those who were married, who were solemnized, the marriages were solemnized by this particular priest, they were all validated. The reason was their personal rights and the children's rights, they were not recognized anywhere, and they found it very difficult. Of course, it no longer prevails, because all those marriages which he had solemnized were all considered to be valid. This was the British jurisprudence so far as matrimonial laws are concerned. But once again, they overlapped. They overlapped the Criminal Procedure Code, they overlapped the Indian Penal Code, they overlapped various other civil laws also. Post-independence, 2 specific acts. I will not talk much about the Mohammedan law, because Mohammedan law was mostly customary law, practiced in those days. But let me tell you, when the disputes landed in the civil courts during the British jurisprudence era, they were actually decided by the courts after taking advice from Pandits and Maulvis in the court. Of course, the jury system has been abolished in independent India much thereafter. We have the Hindu Marriage Act, which is more or less the parent act that they say, which governs a majority of the people. But what is important for all of us to know is that in the short period of 75, 77 years of our independence, just see the progress that we have made, the kind of progress that we have achieved. I must tell you that I am really proud that our country has achieved progress in terms of enactment of laws, to showcase that it is no longer a developing nation. Though in my write-up I have said that it is a developing country, but let me tell you, we need to take pride in ourselves that we are no longer a developing nation, but we are a developed nation. And the Indian jurisprudence starts with the Hindu Marriage Act and the Hindu Succession Act. It is very well entrenched and well developed. Courts of law have passed so many vital judgments over a period of time. But a majority of the matrimonial laws in the Indian jurisprudence were in fact developed much after India opened up as an economy to the world at large. So in the early 90s, because of liberalization, when India opened up, and as the learned family judge rightly said, during our times, we did not have Google, we did not have so many, avenues for getting things done faster. But those days were really those days where we did not have any distractions, unfortunately. So the only distraction for us was to nothing but study and just talk to our friends and play some games socially. That was the only thing that we did. Believe me, I grew up playing marbles. I used to love to fly kites, and I grew up playing social cricket. Social cricket is with a rubber ball or not the competitive cricket that day. You know, sports, racket sports like badminton, tennis were a distant dream. And so far as golf is concerned, we could only dream in our sleep. So this is how we grew up, you know. But today's times, they have opened up. So the idea to put forth this point was only after we opened up post-liberalization in the early 90s to the world that we saw a plethora of laws which may have been there, but which started developing from the perspective of evolution. And those evolved into substantive rights of the parties. You know, we had an act. In 2005 the DV Act was one of the acts, you know, which really brought about the revolution. They say when our president, you know, Justice Kalam, he gave assent to that act on the 26th of October, I think in 2005. That was a very remarkable and a revolutionary kind of a day, you know, because all of you all know how the DV Act defines share household. The moment it talks about share household, we go to the next step. A share household can also be by people who are not legally married and who have been living together, who may have children from that marriage. Now, how would their rights be governed? So all this is nothing but the evolution of matrimonial laws in the Indian jurisprudence. On the flip side, we all should also be aware about many other laws which touch the society at large. Though we may try to run away sometimes, but let me tell you, it's our solemn duty, bounden duty, to see what we can contribute toward these kind of laws also. What I'm talking about is the transgender law. So many laws. I'm talking about the LGBTQ plus. That plus, I do not know how many more categories would be there. But, of course, it is laughable, but let me tell you, we all need to be aware about what's happening, because that is nothing but evolution in the Indian jurisprudence. Ultimately, something which has life needs to be protected. Because we all talk about Article 21 all the time. Fortunately, it's good. Article 21, the Supreme Court has interpreted that right to marry is not a fundamental right. That has been done as recently, you know, in the Supriya Chakravarti case last year by the Supreme Court 2023, INSC 922. So that case, the Supreme Court has, said, oh, right to marry, okay, under Article 21 you can have a right, but it's not a fundamental right. I'll tell you the paragraph number also when I'll just come to that. So, apart from this, there are very curious statutory provisions which I want to tell you all and share with you all. They are there in the write-up. Section 122 of the Indian Evidence Act. Now, those who have been practicing, I am sure none of us may have used Section 122 in any of our cases as yet. It hardly happens. But believe me, maybe in the constitutional courts, I had the occasion of hearing it once. In the constitutional court, they do take up Section 122. Now, what is Section 122 of the Indian Evidence Act? It is spousal privilege. Just as you have legal privilege, if your client discusses anything with you, you are not supposed to disclose that, correct? Similarly, under Section 122, a right is given to both the spouses not to disclose, despite which we find that in every petition that is filed in the family court, which travels to the High Court, Everything that is discussed between the partners is found in the petition. Not only in the petition, but it is found also in the legal notices and the replies that are exchanged between the parties before litigation is embarked upon. See how beautiful it is worded, but the whole problem is we take it in a different way. Section 122 says no person who is or has been married shall be compelled to disclose any communication made to him during marriage by any person he is or has been married, nor shall be permitted to disclose any such communication unless the person who made it or his representative in interest consents, except in suits between married persons. Very difficult proposition. And the court says that this calls for the highest standards of evidence if you want to disclose. Another curious provision of law is Section 29 of the Hindu Marriage Act. That is not there in that write-up. You can just make a note or an entry. Section 29 of the Hindu Marriage Act, very interesting phenomena. It gives statutory recognition to customary divorces. So if there is a marriage and if the spouses want to separate, and if they find it very difficult to go under any of the provisions of the Hindu Marriage Act, this is the best recourse for them to take. And all that they have to do is to lead evidence on this. There are hardly any cases on this, but this is also crucial. It also again calls for the highest degree of evidence, because this is nothing but a shortcut to divorce. Now, these evolution of matrimonial laws during the Indian jurisprudence era also impinge upon the rights of Indians who are living abroad. So therefore, we have a plethora of laws for that also. We have the NRI Bill of 2019, which impinges upon the rights under the Passports Act and the Criminal Procedure Code. Now, what happens to these people, who are Indian citizens, who are abroad? So there, as early as the 1892, we had the Foreign Marriages Act. So Foreign Marriages Act 1892 was enacted to supersede the Indian Foreign, was superseded by the Indian Foreign Marriage Act of 1903. And then it was replaced by the 1965 Foreign Marriage Act. Now, what is this act? This act governs the rights of the Indian citizens abroad. If they want to get married, they can take assistance of the diplomatic missions. They can take assistance if anything relating to their matrimonial issues are required. But then there are certain shortcomings here also, which we have found in the Indian jurisprudence. If India is not a signatory to a particular convention, it finds very difficult for extradition. So all of you all are aware about the Hague Convention, where 75 countries, qua matrimonial laws, have appended their membership and signature, but India unfortunately has not. So it's very difficult for somebody to be extradited, So it is very crucial that all these things are all evolving all the time. And ultimately it's the parliamentary democracy system that we follow in our country which evolve past the legislations and the laws. But believe me, each one of you can make a difference. Each one of you. For any law. And that is what I want to tell all of you all. I'll give you all an example of an English lady called Beverly Portland. In England, sorry, not in England, in the US, they celebrate the Independence Day on the 4th of July. So, a lot of people burn firecrackers. But the prevalent practice there was to burn firecrackers well before that date and continue doing it even after that date. And it used to cause a lot of nuisance, noise pollution, as well as air pollution to everybody. This lady single-handedly, she started writing letters to every MP, the parliament, the prime minister, the majesty, everywhere, every senator, everybody. And believe me, single-handedly, she made a difference. Cognizance was taken, the issue was debated in the parliament, and a law was passed. And the restriction was only for 10 days, before and after. So the reason why I want to share this with you all, and in fact, many a times when I do a lot of hearings in my court, I also tell the young juniors who appear before me, please be a change. You can be a change. If you find that there is some aberration, and if you can provide a thought process, please write. It's not going to be wasted. Somebody or other is bound to take cognizance. I always encourage that whenever we have a seminar, we should always have a white paper on the seminar. We should send that white paper to the Law Commission. We should send it to the Chief Justices. Because we have administrative committees in our courts which take cognizance of these things. What's happening around. Things are acted upon. We send them to the legislatures. We'll send them to the Supreme Court. The Supreme Court might send it to the government. We can all be a change. The only problem is, please don't hold yourself back. So, the most recent phenomena was the 3 new legislations, the Bharatiya Nagrik Suraksha Sanhita, the Bharatiya Nyaya Sanhita, and the Bharatiya Saksha Adhiniyam. Be that as it may, whatever names they are called with. What is important is, whatever little change has occurred or has been enacted, we all have to embrace that. We all know things have become more lucid, more prevalent, and more significant. There is no point in criticizing anything in life, because if you criticize, what happens is you don't progress. Your mind gets clogged. You ask yourself this question. If you start thinking about criticism in your mind, you will be filled up with 100 negative ideas immediately. But if you try and think anything progressive, you will have to think about even 5 or 10 ideas. So therefore, what I want to tell you all is, criticizing is very easy. So don't look at the pessimistic side. So with this, let me come to the case laws, the interesting case laws which I will just quickly introduce, because they are very interesting. When you all go back from here, you all need to take back something interesting so that you all can, on your lunch table or on your dinner table tonight, can share it with your family. So some interesting case laws, which I have noted down. We are all aware about the Shah Bano Begum case, where she sought maintenance under section 125 of the CRPC, and it's become a revolutionary case, This was to answer the question as to how people take advantage of the Special Marriage Act, and then end up getting married. It was followed by a very wonderful case. The Sarla Mudgal case and the Lily Thomas case are also on the same lines. Because of this remarriage, how do the rights govern? Well, one interesting case which I've placed over here is the irretrievable breakdown of marriage case. The Naveen Kohli versus Nitu Kohli, AR 2006 Supreme Court. Now, I have something to say on this. Though the Supreme Court said that if a court finds, and this is more so for the family court judge and all her judges, can we just simply accept it? Many a times, I was just discussing with a learned judge, and I was telling her, the trial judges find it very difficult to take a decision. And then what happens is, to play safe, they just say that, very well, let's dismiss it, let the higher court or the constitutional court decide. Of course, if there is irretrievable breakdown of marriage, ultimately the court can take cognizance. But see the flip side of it. Are we going to give an alternate to somebody to come to the court and say, oh, we have got married, but there is irretrievable breakdown because of incompatibility, nothing doing, we are not going to stay with each other, we want divorce. What it will probably lead to is a disastrous result, and that is what the Supreme Court was cognizant of. In 2010, when this particular case was once again cited before the Supreme Court, and it was urged to the Supreme Court that why don't we lay down the law to be followed by all the courts? You know what the Supreme Court said? It said that in 2006, that was the opinion expressed by the judge who wrote that judgment. We can't lay down the law in such matters which affects our country and the diversity of our country in such a manner. And we leave it to the wisdom of the legislature and the parliament to decide the law. Let them make the law, we will implement it. Because we all should know, of course, it is a ground in a given case where there is adequate evidence, undoubtedly. But I want all lawyers to know that irretrievable breakdown of marriage can always be misused to a large extent. And therefore, we all need to be very careful. The next case, which you may not find it because I just jotted it down, it is Seema versus Ashwini Kumar, 2006 Supreme Court. You know, the Supreme Court in this case has directed all states to enact rules for compulsory registration of marriages. And therefore, when I began, I told you all that even today, some states we are having some degree of some problems. Now, in 2006, the Supreme Court says, enact rules for compulsory registration of marriages. It has given the mandate to the NCW, that is the National Commission for Women, which has spearheaded this particular diktat of the Supreme Court. In this very judgment, the Supreme Court has also stayed the legal validity of marriages of girls who are below 18 years. See, we all need to know this because we will all be facing these kind of problems and issues during our practice life. You will have a lot of people inquiring, and this is where you need to know what the Supreme Court has said, when. But then, do we have the law in place? Please see. This is in 2006, Seema versus Ashwini Kumar. When you read that judgment, we just tell ourselves, we are almost 18 years down the line, but where is the law? Then we have Lata Singh versus State of UP, again in 2006. The precursor case, Lata Singh versus State of UP. Intercaste, interreligious marriages. And I think as far back as last week only, we are still reading in the newspapers about these problems. People are rushing to the court, seeking protection. Just see, the Supreme Court in 2006 lays down. This was an interesting case. In my write-up, I did not quote the entire paragraph. I just took the paragraph to play it very safe. But if you get time, please read this case. Supreme Court has commented. Justice Markandeya Kajju, he has commented, and I didn't feel it right, so I just put down whatever was relevant for the purpose of today's lecture, and speech. Supreme Court has said that acts of violence and threats against intercaste couples are wholly illegal, and those who commit them should be severely punished. Diktat is given to the administration and all police authorities all over the country to ensure that every intercaste couple, if it is harassed or faces a problem or any threat of any act of violence, they can always come to the police, the law enforcement agencies, and seek help. This judgment had to be passed because of a lot of prevalent problems, which came to light in the first decade of this millennium, when most of y'all were just born, the students. The khap panchayats, the honor killings, and they are still continued today. Remember one thing, we cannot make a change in its entirety, but we need to make an attempt to make the change. It is always said that no matter what one does, it is not going to make a difference to the society at large. No, charity has to begin in your house, at your doorstep. And each one of y'all, when y'all embark upon this journey as a lawyer, and then ultimately if y'all become a judge also, we are all trying to see to it that we make a change. We attempt to make a change. The Navtej Singh Johar case is one case which I would recommend all students to read. 2018 Supreme Court, it decriminalized Section 377. I think it's not there in the write-up, but this is one judgment which I recommend as a read to all students, equally all of us. It's written, there are 5 judgments. The principal judgment has been authored by Chief Justice of India, Deepak Mishra, up to paragraph 272, and then 273 onwards, Justice Nariman has authored it. Thereafter, Justice Chandrachud, he has authored it. Justice Indu Malhotra and Justice Abdul Nazir. Now, when you read all 5 of them, I am telling you, you will get a different perspective to life. All 5 of them, 5 judges have written it so beautifully. Ultimately, they have all consented that yes, 377 needed to be decriminalized to that extent regarding the consent issue. What I want to tell you all is, in the Indian jurisprudence, within a span of merely 65, 67 years, we could take this decision and knock off 377. Though 377 was put in the IPC in 1861 when it was enacted, you all will be surprised to know that 377 was put in the Indian Penal Code in a very, very refined manner, because the precursor to that was known as the Barbary Act in England, which was prevalent in England, enacted in 1445. The Barbary Act, and the punishment was capital punishment. You will be surprised that the Barbary Act was repealed by in England in 1967. From 1445 to 1967. So for more than 5 or 5.5 centuries, they had this law. But look at our Indian diaspora. Within 68, 67 years, we had the courage to knock off this decriminalize Section 377 to that extent. And that is what I call progressive legislation, So if you get time, read, it's a very lengthy judgment. It's a full volume of the SCC, running into probably 400 pages, the entire judgment. Navtej Singh Johar. But all 5 judgments will make very interesting reading, and I'm sure it will enrich all of y'all. Whenever y'all go to the library, just take up this 2018 volume of the SCC and just go through it. And I'm sure the enrichment will be such that y'all will be drawn into it also. The Supriya Chakrabarti case to 2023 decided 3 fundamental issues in September 2023 by the Supreme Court. And that is what I call the Indian jurisprudence is evolving, and it is keeping on evolving day by day. The 3 issues which were decided and which were commented, very lengthy judgment, very long judgment. Is marriage a fundamental right? The Supreme Court says no. Then right to transgenders, rights of LGBTQ. The only thing is that we are on a journey. And on a journey, remember one thing, every day we learn, every day we evolve, every day we try and make a change. And that is the message that I would like to send to all of y'all. Now, before I part with, I have put down some trivia, marriage laws across the world from an article which I came on the internet. So some bizarre laws, in Saudi Arabia, it has banned male citizens from marrying women from 4 countries. So I was intrigued. Why women from Pakistan, Bangladesh, Chad and Myanmar were, chosen? So I did a little bit of more research on this, and I found that the reason was because of a lot of proprietary rights in Saudi Arabia. So the locals who were locals in Saudi Arabia, they are barred from marrying because of proprietary rights. Now in USA, they have this proxy marriages. I don't know if we progress, probably proxy marriages can be had here also. In fact, when I was discussing the trivia section of my speech with my team yesterday during lunch, one of my law interns came up with this brilliant thing, and he said that in India, they have certain marriages called Manglik marriages, or I don't know what, some words he used which I don't recollect immediately now. He said in these marriages, the marriage is performed with a banana tree or a dog or a cat. And he told me there is a reason, see the customary effect is still prevalent. And this becomes, it just shows us, it shows us a reflection of what is there in the society even today. So, this is the bizarreness of the laws which are still prevalent. In Japan, why is it that after divorce, women have to wait for 6 months? For what? When the same condition would not apply to men. What is the reason behind it? I tried to find out, I did not. If you all know the reason, let me know. Because there's very little literature about Japan, and we can't read Japanese, we can't speak Japanese. China and Japan, the Mandarin language and the other languages are a little difficult. So therefore, I find it very difficult to understand the history and the culture, Then in France, we have posthumous marriages. Now these were evolved during the World War, posthumous. If after someone dies, the marriage is performed with a dead man. Now in Monaco and Greece, marriages are required to be announced in public. Now Monaco is a very small principality of a few thousand expatriates, in the south of France. So it's a very rich country, they can afford to, because they have to be announced in public. But in Greece, there is a very interesting thing. It says that you have to announce your marriage in the newspaper. So this is again an interesting phenomenon, In England and Wales, of course, there is a law which states that couples must marry in a fixed structure having a roof. It is prevalent even today. This is primarily because of the word sacrament which was used by the learned family speaker. It derives its origin from the Bible and the studies, and they say that yes, it needs to be solemnized by a priest. So it has to have a fixed structure so that you can have a fixed future. So that is why the law says that you will not get married into the open to sky garden or those things. Of course, in Brazil, men had 10 days to annul their marriages if they discovered that their wife was not a virgin, but that has now been repealed. Now, all in all, a very interesting exercise which has been done by this Vidhi Foundation to involve students. What we find, because when I was sitting over there, when the earlier lecture was going on, I found the speakers encouraging the students about Marathi language, about their gestation period in the field of law. So what I want to tell you all is very simple. If you all are students, use your time as a student to know what is in the offing for all of y'all. Don't start your legal practice after you acquire your degree. Don't do that. Because if you do that, your gestation will get slightly longer. And one of the speakers who spoke to y'all rightly said that कोणाला 6 महिने लागतात, कोणाला 1 वर्ष लागतो, कोणाला 2 वर्ष लागतात. You know, it's true actually. It's true. It all depends upon the 3 I's which are introduced to you all in the inception. Industry, intellect, and integrity has to be inherent. So everything is I, and I. So when you embark upon your journey, embark upon your studies, don't hold yourself back. One of the biggest problems which I found, because I give a lot of orientation in the colleges, in the districts, I like to interact with the students only to inspire them and tell them that, look, even you can be where I am today. All that you have to do and have is resolve and nothing else. It is possible. Let me tell you that. It is absolutely possible. The idea is to just inspire. But the problem which many students, when they interact with me and tell me, is that they feel very insecure. They feel insecure about what? One of the most common problems which the students face, which this foundation has taken up, is language. So, you know, I tell them, I give them the answer to that. I tell them, you have to forget the language. First and foremost, there are 2 things which you all have to imbibe. All of you all, all students, especially the students. Believe in the power of asking and talking. Don't hold yourself back. Worst comes to worst, what will happen? If you ask a favor to somebody, if you ask something to your teacher, if you ask something to a lawyer at the bar, what will he do? They will say no to you. The problem with the students which I found was, once they hear a no, they take it like a rejection in life. So I tell students, believe in the power of asking and don't take a no as a rejection in life. Some students categorically tell me on my face that, sir, we feel very insulting. It's like an insult. They say that maybe because of our background, foundation. No. All these things are matters of circumstances. I was discussing with the learned family judge in the morning and the others also. We all come from different backgrounds. We've all had a different schooling. We've all had different parenting. The problem is, everything is now getting assimilated together in the profession. And all that we have to do is, we have to just learn what we have not learned. As simple as that. So, these 2 fundamental principles, believe in the power of asking. Ask for something, what you want. Ask. You know, when I embarked upon my journey, and I thought that I would like to do indirect practice in the High Court, in constitutional courts, I had to go and meet somebody because I was a first generation lawyer. Even that topic was broached by one of the speakers earlier. First generation lawyer. I didn't know anybody. First of all, you know, when I started my internship, I did not know that there is a High Court also. I only knew about it in the books that I read. The structure, Supreme Court, High Court. But in Bombay, I thought the small causes court was the High Court. That's primarily because, you know, I was clouded that who is going to help me? But once I entered the precincts of the court, you know, these are the principles which I started following because of a few good common friends with common interest. And that is why I tell you all, you know, friends with common interest forms the fundamental basis of all students. They are the ones who pushed. They are the ones who are going to push all of you all. And once you do that, a first generation lawyer does not make a difference. So, power of asking. I went to many seniors. Most of the seniors told me, "Arey, you speak well." I think because I was working in the central government. So they told me, "I'll find a job for you with a good solicitor's firm. You did not join me as a junior counsel, you know." So I used to tell them, "I'm sorry, sir. Thank you very much for being so kind, but I don't need your help." And so, many a senior, some of them used to tell me, "You're very arrogant." I said, "Maybe I may have given that impression, but I have something in my mind. And until I get it, I'm not going to leave it." No matter how many insults I face, So this is one thing. Remove the issue of embarrassment that you have in your mind. The degree of insult that you feel or the rejection that you feel if somebody says no to you. A no does not mean a rejection. Remember that. All students. And the second thing is, which I want to tell all of you all, which applies to even the seniors sitting here. Please be transparent and don't try to look good. तुम्ही जसे आहात तसेच राहा. The reason is, you are in an intellectual world. You can't be pretentious. You can't pretend. तुम्हाला असं पटकन पकडलं जाईल. And then what will happen? You will lose out on opportunities. I tell students that when you are in your student life and studying law, equip yourself with knowledge. Primarily because we don't want somebody to feel that he's belonging to a big block of mediocrity in the legal profession. So when I have interns in my chamber, the exercise that I give them is like school children. I tell them, you'll have to read 2 English newspapers, the middle pages and the edits every day, and 1 vernacular newspaper. Primarily, if you know Marathi, then any Marathi newspaper. If you know Gujarati, Gujarati. If you know Hindi, Hindi. You have to read that. Why? Because of current affairs. You need to know current affairs. Otherwise, you will never be a head turner. Your gestation will be very long. And believe me, the interns, the law students, they ask themselves, yes, do we want to improve or not? And that exercise they follow. There's one more exercise which I give to some of my law interns. I tell them point blank within a couple of days after they join my chamber, well, I find that you have a language problem. Don't worry. Write a 3,000 word article every day. All that they have to do is to write an essay every day, copy it. So then they tell me, sir, we are very adept with laptops and iPads and all that. I said, no, handwriting. Because that's going to showcase your personality, your handwriting. That's going to improve your motor and sensory skills. And most important, which we all require in our profession as a lawyer, retention of memory. If you are not able to retain, how will you draft? How will you argue? So retention of memory is very crucial. For that, this exercise is required. And believe me, within 6 months, you get fabulous results. And I tell them, what are the results? They feel supremely confident. Because they say that, yes, we have started hearing new words. And sometimes I get students who are not able to talk because they hold themselves back. So for them, the exercise is they have to read what they have written in front of the mirror and hear their own voice. And again, the results are good. Within a couple of months, I find them interacting. The reason is because when you will step into the legal practice in the bar, you will be surrounded with a lot of G forces, market forces. And at every step, you are going to learn something new. And at that time, you will not have time to do this exercise. So therefore, the students will have to pull up their socks if you have chosen this profession. It was known as the noble profession. I don't know how far it is true today. The nobility of the profession was in the fact that the gowns that we wear, it had a slit, the lawyers wear, it had a slit. And the lawyer or the advocate would not know how much fees his client has given to him. It was supposed to be put in that slit. That was the degree of nobility of this profession. And this was merely as far as until we gained independence. The nobility of the profession, I do not know whether it does exist or not, because now it has become a commercial proposition. But let me tell you, we need not look at the flip side, the pessimistic side. Each one of you all, whether you are a student, whether you are a judge, whether you are a professor, remember that you have a role to play in society at large. If not the society, at least you have a role to inspire your family, your children. And therefore, all that I would like to tell you all is, engage yourself. Don't feel sad. Don't get disheartened. You are in a wonderful profession, I must tell you that. This is one profession where the legal profession, even if you do not feel that you are cut to be a lawyer, you can do anything else in the world, anything that interests you. I have had many juniors, interns, and they've been asking me, many a times, sir, do you feel that I'm fit and cut for the legal profession? So a couple of them at least I've told them that no, I think you'd be a better businessman. I'm telling you, it makes a difference. The idea is that once you choose something, it does. See, because your studies are something which are going to orient you. But ultimately, it is you who decide your life and the future of your life. So, wish you all the very best as students in this profession. Welcome to the profession. I'm the Vidhi Foundation, I had heard about it for the first time. They're doing a wonderful job. I'll just tell them that next time, instead of having a monologue dialogue, let's have workshops for the students where, the interaction of the students, where they talk even the basic things which come into their mind. And, because we have to have progression in our foundation, in the activities of the foundation also. It's not merely that we have monologue lectures, somebody speaking and somebody listening. So we can have interactive sessions, workshops, where we can, also ensure that, because see, one of the things which the president mentioned was about the permission that they got. It's a very wonderful thing. Most of you all should take advantage of that. You all will be escorted to the jails. In the jails, you will be hearing the story from the under trial or even the convict to that matter. And they require your services to write letters to the High Court. They require your services to draft petitions. It's a wonderful experience, I must tell you that. Apart from drafting, you'll be introduced to a diaspora of something. And if you have a penchant for practicing criminal law, it's wonderful. Believe me, one of the reasons which I attribute to wherever I am is only because of Marathi language. Because my Marathi was very good, I got a lot good work, in the revenue tribunal. Nothing wrong if you are good in Marathi, if you are good in Hindi, good in Gujarati, whatever it may be. Develop that also. Don't give it up. Don't feel embarrassed to read a Marathi newspaper, please. This is something which I have found in many students. त्यांना असं वाटतं की आपण मराठी वाचलं की समोरचा काय विचार करेल. हा विचारच करू नका तुम्ही. The amount and the plethora of current affairs at the ground level which we get in vernacular newspapers, you will not get in English newspapers. Let me tell you that. In the English newspapers, you will be inundated with a lot of progressive articles. But the vernacular medium language is so crucial for you all. It's going to help you all to be successful in life. Wish you all the very best, all students, all the members, all the faculties, the members of this foundation who invited me to speak. I wish you all the very best in life. Stay safe, stay healthy, take care of your families, and sorry to take your time. Thank you very much for tolerating me.